Welcome back to the discussion sofa. I have to say I'm rather comfortable talking to you about legal issues sitting here, so let's get to it. I've had an email from Paul, which is a very interesting email about privacy issues and apps that require your personal information, such as your location. The email reads, some companies try to force you to give your location to use their product or service. Usually there's no reasonable need for them to collect this information, and I don't believe, Paul says, it passes the test for collecting personal data proportionate to the service being offered. When I've emailed to query this, I get no reply. And then goes on to give some examples of modern tech that is insisting on having your personal location whilst using their app or service. So for that reason, I thought I would talk about this issue a little bit, and of course in respect of the data protection principles. Data protection is very heavily guarded within the UK and within Europe, and indeed internationally, and much to the dismay of some people around the world that are going to find out that GDPR can be enforced around the world, the fines levied and so on. I'm going to talk about some of the principles that apply here, particularly with respect to GDPR and the UK's Data Protection Act. So, first of all, what is personal data? It doesn't have to be private data. It doesn't have to be that information that you only keep private and that you don't share with anybody else. It's not just that. Personal data is anything that can identify a living, natural person. So it could be anything from your car registration plate, because that, taken together with other information, can determine who you are and where you live. Where you live can be information that can determine who you are. Your phone number, your name, your age, your date of birth, including email addresses and any other online handles, monikers, and so on. They can all be personal data, but even your interests, your beliefs, any disabilities, anything like that, all of which could be personal data, because any one bit of information taken together with something else, either that's freely available and accessible or held by the data controller, if that can identify who you are, it's personal data. So all of it is encompassed within the data protection legislation. So with that said, there are certain principles about collecting personal data and rules about how you store it, for how long, what the purpose is, and so on. Those principles, very broadly speaking, firstly, lawfulness, fairness, and transparency. So obviously it has to be lawful. It cannot be obtained secretly without your knowledge. It's got to be fair. In other words, the amount of information that they collect has got to be fair. The way that they collect it has got to be fair. And all of the principles about how they store it and so on and how they use it have to be fair. It has to be transparent, meaning they have to tell you what data they're collecting, how they're storing it, with whom they might share it, for how long, and how they process it, and so on and so forth. Another principle is data minimization. They should only collect that which is necessary for the purpose that they've collected it for in the first place. So they shouldn't be collecting everything about you if all they really need is your email address to send you an update for a product order, for example. They won't in those circumstances really know, for example, whether you have a disability, unless of course it relates to a special adaptation or reasonable adjustment to make that delivery happen. In which case you would have been asked the question during the sign-up process or whatever it might be to specify that you need some reasonable adjustment because you have a disability. This principle of data minimization means that they should only collect what is absolutely necessary and no more. Any more than that, and it might be a breach of the data protection legislation for which you might be able to bring a claim. Accuracy. The information has to be accurate. Biggest example is credit reference agencies. If they have something on your file which is wrong, then it can affect you negatively in many different ways. You've got the right to have this corrected, and this is one of the principles that it should be accurate. Storage limitation. How much of it is stored, for how long it is stored, where it is stored, and how secure the storage is, with whom the storage is shared, whether it's transferred outside of the jurisdiction, and so on. There are principles around the storage of it as well. This leads neatly into the integrity and the confidentiality, which is otherwise referred to as the security of the storage of this data. It should obviously be secure, that goes without saying, but as we've all heard of numerous data leaks, there's one case which is just about to get filed with over 1,000 claimants, a multi-party, or internationally you might call a class action lawsuit, against a company because they leaked the name, the address, and various other bits of information to people party to a financial agreement. That's obviously a breach of data protection, and there's potentially damages that can arise from that. Moving on to the processing itself, there's got to be a lawful basis. This is quite broadly consent, but you've got to be careful if the companies are relying on consent. It's got to be informed consent. You've got to inform the person that you're collecting this data what you're collecting, for how long you're collecting, and it's got to be an informed and conscious choice. No good just having a pre-checked box to say that person consented. That's not good enough. The person has to check that box themselves. There might be a contract in place, in which case there might be terms and conditions as to what data and information you are collecting and storing, for how long, and so on. A legal obligation, there might be a legal obligation. For example, finance firms or other law firms might have a legal obligation to store your data for a certain amount of time. And there are various other things. So coming back to Paul's question, whether these apps and services should insist on your location to provide you with a certain service, I think has a very good chance of going beyond the scope of data protection and beyond that is necessary, reasonable, proportionate, transparent, and so on. And so if they are insisting that they have your location and otherwise preventing you from using the service, whilst that might be under their terms and conditions, it may not be fair in accordance with data protection legislation. So I thought that was a very interesting topic just to broadly cover those principles, because many companies think they don't have to pay attention to data protection legislation, but they would be wrong. And GDPR does apply internationally, and I for one would support the fining of companies internationally that breach this legislation whilst collecting and processing data on EU and UK subjects without their consent and in breach of the legislation. I hope that was a useful overview. Please like the video and subscribe, and drop your thoughts and comments down below. Are you happy that your data might be floating around there somewhere without you knowing about it? See you next time.